Good evening, and thank you for attending this webinar. I'm Susan Hauser, serving as the president of the League of Women Voters of Alameda. Tonight's program is an informational one, not an advocacy forum. We are bringing the topic to you for your consideration. A few housekeeping items: guests, microphones, and cameras are disabled. In other words, you won't be able to speak to or be seen by the group. However, there is a Q&A function on the screen. If you have a question, please type it in there, and the panelists will do their best to respond. The program is being recorded and will be available after a few days on our website for people who wish to see it. When the slideshows start to appear, you may adjust your view on your screen. Those with computers may do so with the View Options button or the View button. Both will appear at the top of your screen when the slideshows begin. Those logged in by iPhone or Android should be able to move the picture of the speaker around with your finger. Tonight's webinar is on campaign finance reform. Alan Mann, League member, journalist, and business manager, has assembled a panel of experts. Patrick Ford, Senior Policy and Legislative Affairs Counsel with the San Francisco Ethics Commission, and Austin Graham with the Campaign Legal Center in Washington, D.C. Alan, I'll hand it over to you.
Thank you, Susan. We're going to be following the money tonight in Alameda politics by taking a look at campaign contributions and their impact on local elections. We're going to be addressing two questions. Is it time to regulate campaign contributions? And if so, how? Tonight's speakers, as Susan said, include two individuals who've been totally immersed in this issue for some time and spend most of their days on it. Graham Austin will be speaking first. Graham is with the Center for Campaign Law, who is looking across the country at policy issues related to campaign financing, and he will provide the national view. Following Graham, we will hear from Patrick Ford, who's with the San Francisco Ethics Commission, and he will give us the local view from across the bay. But first, I want to talk a little bit about what the League has been doing and what we've learned. We've been tracking campaign contributions for the last several years, and in the last 2 years have put together a number of graphs and tables, which you can find on your website, that go into great amount of detail as to how campaigns are being financed in Alameda, where the money is coming from, and who it's going to. And I believe this URL, which will enable you to get to the right page on the website, is going to be put in the chat at some point. So what have we learned? First of all, unsurprisingly, the amount of money that's being raised in campaigns is increasing dramatically. This particular slide shows the increase in campaign contributions strictly to city council during the last 5 election cycles. These numbers in parentheses are the number of candidates for each. And as you can see, the increase has been pretty significant. It's about 2.5 times the amount of money that was contributed in 2020 as in 2012. And even if you control for inflation, which is what this orange line is doing, it's still double. We also know that candidates who have raised the most money are most likely to win their city council elections. This particular slide shows for each of the elections, the last 5 elections, the individuals who are ranked here by the amount of money that they had contributed to them. And the ones in dark green are the ones that got elected. The ones in light green ended up on the council, but only after finishing 3rd and getting a vacant seat that was freed up by one of the council members being elected mayor. And those in The squares in yellow represent candidates that did not make it into the top 2 or 3. Well, as you can see, in virtually every instance in the last 5 elections, the person that collected the most money also had found themselves elected to the council. And in 2016 and 2018, it was the top 2. Now, there are outliers here. It is not necessarily a one-to-one sort of a proposition, and there are those who have gotten to the council with less than top-ranking contributions. In a number of those cases, they were individuals that already had pretty good name recognition for having served on the council before. But the bottom line is that it's hard for newcomers to break in without major funding. Now, we also have learned that much of the money that is contributed to campaigns is coming from outside Alameda. This slide and the couple that I'm going to show you now focus entirely on the November 2020 election, but in addition to city council, we're reflecting contributions to all campaigns, our school board for Measure Z, and also money that was contributed to independent expenditure committees. As you can see from this pie chart, money from Alameda constituted about 60% of all the contributions, but $4 of every 10 that was contributed to all campaigns came from outside the city, either within California or outside California. We've also learned that a majority of the money comes from organizations. Here again, focusing on the 2020 November election, but all contributions to all campaigns, we can see that individuals contributed about 40% of the total, whereas 6 of every $10 was contributed from either business, unions, or from political sources. Another thing that we've learned is that most of the money that is contributed in large amounts. Again, all campaigns, the November 2020 election, the contributions of 1,000 or more aggregated accounted for 7 of every $10 contributed. Now, the question is, does this affect the elections? And there are a number of questions that we need to look at. First of all, do major contributors have more impact on the outcome than individual voters? Secondly, could public policy be influenced as a result of that influence on the election? Will people be discouraged from running for office due to the high cost of doing so? And will individuals be discouraged from voting because they feel that if they're not supporting a leading candidate, their vote will not count compared with the large amounts of money that candidate is getting from other sources? So the question before us really, and before the league, is should campaign contributions be limited by size or source, or perhaps both? Now, we did take a look at what other cities in Alameda County were doing and others in the Bay Area. And we found that half of the cities in Alameda County do have some form of campaign finance rules. Those with campaign finance rules include this list, and those without campaign finance rules include Alameda and the balance of the communities in the cities in the county. We should note that rules for Alameda were proposed in 2011, but were not enacted by the city council. Now, there's a footnote to this, which is that now even cities that don't have campaign finance regulations have campaign finance regulations, because a new state law that went into effect January 1st put a cap of $4,900 per contributor per candidate. For cities that do not have their own regulations, this becomes the default. Now, this covers city council elections, but not school board elections, measures, or contributions to independent expenditure committees. Cities can opt to have stricter or more lenient limits if they like, but those with no regulations, like Alameda, will have to actually set those limits in order to make that happen. Now, looking around the county, as well as across the country, what are some of the typical types of campaign finance rules that are in place? Many cities have elections and or ethics commissions, and you'll hear a little bit more about that from Patrick tonight. Generally, these commissions either recommend to the council or to the electorate campaign finance regulation, and they monitor what's going on with the elections to see if there are any issues and to make sure that those regulations that are put into place are actually effective. Secondly, as mentioned before, many of the communities have some level of contribution limits, although, as I said, now all of them do by default. Many communities also have voluntary expenditure limits, and these are often tied to a public funding scheme where candidates that agree to these voluntary limits become qualified for public funding, where campaign funds are made available to qualifying candidates by the city, which collects the money through its taxes. There are also different kinds of exclusions in place in different communities. The most common ones prohibit any contractor with the city or the school board, for that matter, from contributing directly to a candidate for one of those boards. And in other cases, including in San Francisco, which Patrick will talk about, there are broader exclusions which prohibit organizations such as unions and corporations from making contributions, limiting it to individuals. Many communities also have disclosure rules that go beyond those that have been established by the state. Most often that includes putting more information on campaign materials than the state requires, indicating what the source of the funding was. And in some communities, not necessarily in California, but outside, one of the latest things that I've run across is rules by which elected officials need to tell the boards, the bodies on which they have been seated, whether any one of their major contributors is coming to that body with an issue that will affect them, or if any other issue that they're considering would affect one of their major contributors. Cities, of course, have one or more or several of these in various combinations. Some of them have been in place for a really long time, back in the 70s, and some of them are more recent. The questions I think we need to ask ourselves as we go forward in looking at this, number one, is informing the voters about campaign contributions enough? That is the league doing enough simply by tracking campaign contributions and making sure that everybody gets a chance to see where each candidate or measure is getting the money and make decisions, voting decisions accordingly? If not, do we need to implement some form of campaign finance regulations? And if so, which regulations work in other cities our size, and which are the most appropriate for our situation in Alameda? We also need to ask ourselves how difficult it would be to enact these regulations and what it is that we need to do to make that happen. So that's why we have our two speakers available. They, as I said, they have a tremendous amount of experience in these areas. We're going to ask Graham to go first. Graham is graciously joining us from the Eastern time zone, where it's 3 hours later. So we will allow him to go first.
Okay. Great, thanks, Alan. Yeah, I'm burning the midnight oil here, but I like to spend my nights talking about campaign finance. So I'm going to go ahead and try to share my screen here. All right. Yeah, so thanks again, Alan, for the introduction. I'm Austin Graham. I am legal counsel at Campaign Legal Center. We're a nonprofit, nonpartisan organization that focuses on election law reform at the federal, state, and local levels. I've been at CLC since 2016, and I've been working in campaign finance since 2014. So it's been interesting to watch kind of the field develop and different types of regulations come about just in the period of time I've been involved with this. And so today I want to talk a little bit about kind of three core types of regulations we see in campaign finance context: contribution and expenditure limits, disclosure requirements, and public financing. And you'll see that for each issue, I'm going to talk a little bit about the basics and mechanics of how those policies work, sort of variations on those policies, and then some constitutional issues that they all sort of invoke. So I'm going to talk about contribution and expenditure limits first. So at a practical level, contributions can be thought of as receipts by a campaign or another political group, meaning the money they take in, while expenditures are disbursements, money that's spent by a campaign or other group to influence an election. And when normal people think about this stuff, there doesn't seem to be a huge difference between those two things, but constitutionally, it makes a really big difference. So the Supreme Court, beginning in this famous case called Buckley v. Vallejo, basically set out the constitutional rules around regulating contributions versus expenditures. And looking at expenditures, the court viewed these as a form of direct political speech, basically because they are an immediate expression of the sponsor's views and political message. Whereas contributions, meaning money that campaigns take in, aren't really a form of direct speech. They're more of an associational act. So they don't necessarily invoke the same kinds of core constitutional concerns that you see when you try to limit expenditures. So in this case, Buckley v. Vallejo, we saw the Supreme Court generally set the rule that expenditure limits are generally impermissible, with a few exceptions, whereas contribution limits are allowed under the First Amendment with a couple caveats there. One of them being the ballot measure campaigns, as Alan mentioned. The Supreme Court, a couple of years after Buckley, struck down a couple of laws that tried to regulate fundraising and spending in relation to ballot measures. And the court's rationale for that was because there are not candidates or office holders involved with ballot measure campaigns, there's not a risk of corruption that would justify limiting the amount of money and political activity around ballot measure campaigns. Excuse me. So within the group of policies like that we think of as expenditures, there are two kind of primary types: independent expenditures, which are made with total independence from a candidate or their campaign. And the Supreme Court jurisprudence on these issues basically says independent expenditures cannot create corruption concerns, so there's no governmental interest that justifies limiting them. And then you have what are called coordinated expenditures, which are more like direct contributions to a campaign. And these are expenditures that are basically made in close cooperation with a campaign. In terms of the types of coordination that are common, you'll see kind of material involvement by a candidate with the content of an ad or kind of the planning around an ad, sharing of information from a candidate to an outside group that typically constitutes coordination. And then you'll also see the use of common agents or vendors treated as coordination in a lot of places, including at the federal law. Now turning to contribution limits, basically the judicial test that's used to assess the constitutionality of a contribution limit is whether it's closely drawn to the government's interest in preventing quid pro quo corruption and the appearance of that kind of corruption. And over a series of cases, the court has really narrowed down the justifiable interest in, or the meaning of quid pro quo corruption to really limit that to dollars for political favors. The concept of corruption that you can regulate in the campaign finance context doesn't embrace something like distorting democracy by spending more money than other actors in the political sphere. We often hear the messaging leveling the playing field within the campaign finance reform context, but I cringe a little bit when I hear that, because the Supreme Court has really singled out that language a couple of times in opinions, saying leveling the playing field is not a recognizable reason to limit contributions in the campaign context. And in terms of how courts look at contribution limits, they do grant a fair amount of deference to legislative bodies and where to set contribution limits. The broad test can be thought of as so long as the limits aren't so low as to prevent effective advocacy by candidates, they generally pass constitutional muster. And then another big type of contribution regulation is source restrictions. And Alan touched on this a little bit, but there are three kinds of source restrictions I want to talk about. The first is prohibition on corporations and unions making contributions to candidates. Sometimes these laws also prohibit corporations from making contributions to political parties as well. There's a corporate contribution ban at the federal level, which has been upheld by the Supreme Court. That was in the early 2000s, so that remains good law. And then numerous states and localities also ban corporate contributions to candidates in their state elections. In California right now, their corporations are subject to same contribution limits as individual contributors, so they are permitted to give directly to candidates. But I'm actually aware of a bill right now, AB 20, that would introduce a kind of tailored corporate prohibition for for-profit entities. The next source restriction is the federal law ban on foreign national contributions and expenditures. And this is one of the few federal election laws that applies to any US election. So it applies to state and local elections as well as at the federal level. And that has been in place for a long time. There have been some issues with its scope, and there's sort of ways that foreign entities can potentially get around that, especially when you start thinking about digital media and ads that don't necessarily advocate directly for or against a specific candidate. It's a little bit of a gray area, and that was really put in stark focus around the 2016 election when we saw Russian actors purchase a bunch of social media ads that didn't necessarily amount to express advocacy for candidates, but clearly were meant to influence the outcome of the election. And part of the reason why they were able to pull that off was because the internet, especially within federal election law, is much less regulated than other types of media like TV and radio. And then the third source restriction, which Alan referred to, was what I like to call pay-to-play rules. So this is where a jurisdiction will prohibit or impose special limits on contributions from government contractors or other highly regulated entities. A good example of kind of a different type of pay-to-play rule would be restrictions on contributions from public utility corporations, particularly in states where public utility commissions are popularly elected by voters. We'll see in New Mexico, there's a prohibition on utility companies making contribution to public utility commissioners or candidates there. And in Arizona, it's been a real problem with public utilities spending a lot of money through independent expenditures to influence the outcome of public utility commission elections. So that's kind of what pay-to-play rules are supposed to get at, is preventing those groups that kind of have the potential to capture a regulatory body, kind of trying to stop them from exercising that kind of improper influence. The next contribution issue I want to touch on are super PACs, or what are often called independent expenditure only committees. So the famous Citizens United decision, part of that, which is really the most well-known portion of the case, held that it's unconstitutional to ban independent spending in elections, including by corporations, because independent expenditures, unlike contributions, do not give rise to quid pro quo corruption or its appearance. And then kind of building on that reasoning in a series of subsequent cases, federal courts have said, if independent expenditures cannot corrupt, then in a super PAC or an IE only committee cannot be regulated with contribution limits because they don't pose a risk of corruption. So kind of today, with that jurisprudence in mind, the ways that the types of regulations that exist to kind of handle super PACs are tight rules around coordination. We talked a little bit earlier about coordinated expenditures. So really making sure that, if there is coordination between a super PAC and the candidate's campaign, that counts as a contribution subject to the limits to that candidate. And then, of course, disclosure rules, which I'm going to talk about a little bit more in a moment here. And I just wanted to touch a little bit on local laws in California related to this stuff. So I picked out two what I thought were interesting figures. So in Alameda County level, there's a $20,000 per election limit on contributions to county office candidates, which I thought was really high. And then I picked out the Newport Beach contribution limit. That's for the city of Newport Beach. And they've set their limit right at $1,200 per election per candidate. And Newport Beach, it looks like, has a population pretty similar to what you have in Alameda. So I thought it'd be good to kind of give you an example of what a similarly sized jurisdiction has in place. And then Alan also touched on this earlier, but there's a new California state law. It's called AB 571, which basically imposed a default contribution limit for cities and counties in California that didn't already have contribution limits in place by the start of this year. And so that now applies in your city, as well as any other places that didn't have limits prior to the effective date of that act. But it's interesting, we saw a number of cities and counties in California pass contribution limits that were super high. $20,000 was a pretty common figure right before AB 571 kicked in. So they wanted to make sure that they had these really high limits before the lower state limits kicked in. All right, the next kind of big picture issue is disclosure requirements. Just want to touch on kind of the basics of what disclosure looks like in this context. So we have two primary kinds of campaign finance disclosure. And the first is reporting. And these are contribution and expenditure reports. They're filed by candidates, parties, PACs, and then often outside non-PAC groups that make independent expenditures or other kind of payments related to elections. And in California, independent expenditure committees file the FPPC Form 496, and that has information about contributors above $100 or more to that committee, information about how that committee is spending money. And then the second type of disclosure regulation is on-ad disclaimers. I think everybody's seen these at this point, but these are your paid for by statements that just tell you who is responsible for the ad you're watching. And increasingly, we're seeing states and localities also introduce top donor identification requirements on political advertising. So in addition to that paid for by statement, you see the top funders of the group responsible for the ad. And here's an example of a ad in a California election, which at the bottom there, you'll see the sponsorship ID statement along with major funding from and California Dental Association. So that's that top donor ID that I just mentioned. And then in terms of the constitutionality issues around disclosure, courts have actually been really, really good about upholding disclosure requirements in most cases. Because disclosure doesn't actually limit the amount of money that you can raise or spend in an election, courts consider it a less restrictive alternative to something like a contribution limit or an expenditure limit. And then in Citizens United, the Supreme Court really drove that home by upholding really broad application of the federal electioneering communication disclosure law, which basically applies to any ads that mention candidates within 60 days of a general election or 30 days of a primary. And in Citizens United, the Supreme Court upheld those disclosure requirements as they applied to a documentary on demand film that was really just an hour and a half attack ad on Hillary Clinton, and as well as applying disclosure requirements to commercial advertisements that were just telling viewers to see that. So basically, the Supreme Court said you can require on-ad disclaimers and other disclosure requirements, even if it's just a TV ad that talks about a candidate for 10 seconds or less. And then the reason why the courts are really receptive to disclosure is it supports three government interests: deterring corruption, helping election officials identify violations of things like contribution and expenditure limits, and then delivering really critical information about the sources of election spending to voters. Um, and this last interest, giving the public information about political spending, is really what justifies disclosure requirements for independent expenditures, because as we know, that they cannot give rise to corruption under the rationale in Citizens United. And then I want to talk a little bit about what's commonly called dark money. And there's not a hard definition of what dark money is, but I think of it as basically money spent by a group in elections that is not subject to the same kind of disclosure requirements that apply to candidates or political parties. So, for example, if a nonprofit organization wants to spend money supporting a particular candidate, if that nonprofit doesn't qualify as a PAC under the relevant jurisdiction's laws, typically the public is not going to get much information through campaign finance reports about where that nonprofit gets its money. Likely the nonprofit will have to disclose the fact that it made the expenditure, but you typically don't see information about the funding behind those ads. And we've really seen different types of nonprofit entities emerge as prime dark money vehicles since the Citizens United decision came down. And so, when thinking about regulating campaign finance and introducing disclosure requirements, there's kind of really three key factors to think about, especially with respect to dark money groups. And that's tracing the money back to the real source of the funds. And that can be really difficult to do. At the state level in California, the Political Reform Act does impose some pretty good disclosure requirements on what are called multi-purpose organizations. And that does help you to get back to the original sources of the money. But oftentimes, you'll see really complex multi-chain transfers of funds to obscure the original source, because oftentimes these are sophisticated groups that know what they're doing and know how to avoid disclosure laws. Another key thing to think about when regulating political spending from kind of dark money groups is requiring disclosure of advertisements and other expenditures that don't necessarily expressly advocate for or against specific candidates. The most common type of regulation we see that kind of goes to this point is electioneering communication disclosure. And that was kind of the type of law at issue in Citizens United. And that's requirements to disclose information when you make an ad that doesn't necessarily advocate for or against a candidate, but talks about that candidate in a public communication within a certain time frame before an election. And then finally, I think it's important to stress that campaigns are more and more relying on the internet to reach and target voters. You really have hypersensitive targeting abilities through digital media that you don't necessarily have with traditional media. So it's really important to make sure that when we think about regulating different types of campaign spending, that we include digital ads, and including disclaimer requirements on digital ads to make sure the public still has good information and access to the same kind of information it has when it sees a TV ad about a candidate or a ballot measure. The last issue I want to touch on is public financing. And kind of at a very broad level, public financing is offered in a number of states and localities as an alternative to relying solely on private contributions to finance a campaign. And generally it works as in a candidate opts into the program and agrees to special rules around their fundraising and spending activities in exchange for the public money. And the Supreme Court has upheld public financing as constitutional because it advances the anti-corruption interests that's also there with contribution limits. And it also helps to promote political engagement between candidates and kind of the electorate at large, and kind of frees them from having to focus on special interest sources and PACs to finance their campaigns. Kind of the one constitutional consideration with public financing, where it can go too far, is if the program tries to penalize or really compel candidates into participation. that's where you can get in trouble. It happened in Arizona in 2010. Their program basically gave candidates dollar for dollar public funds when there was independent expenditures in their races, and the Supreme Court viewed that as a penalty on the political speech of outside organizations and elections, and they invalidated that provision of Arizona's law. And then there are a number of cities in California that have public financing. It's interesting at the state level, the Political Reform Act prohibits the use of public funds for campaigns. That's been litigated a lot, but the state courts have held firm on that. But there is an exception for charter cities. They are allowed to enact their own public financing programs. And so we've seen a number of well-known cities in California enact their own public financing systems. And in terms of what we see for types of programs, kind of the original public financing system was based on block grants to program participants. And that's really where the government just provides the participating candidate a big block of money, and that's it for their campaign. That's what they use, and they're not allowed to raise any money additionally once they get that block grant. So that you don't see them really raising any private contributions at all. The second popular type of system involves matching funds. So that's where participating candidates, for the private contributions they received, the jurisdiction will match those private contributions up to a certain amount with public funds. So a good example is in Berkeley, city residents' contributions to participating candidates are matched 6-1 with public to private funds. So that's actually a really significant match. If you give a Berkeley candidate a $100 contribution, the city's going to come in with a $600 match to supplement that. So it really is a great way to enhance the importance and proportional value of small contributions within an election. Hybrids are also popular. Pat, I think, is probably going to talk about San Francisco's program in a minute, but San Francisco has a hybrid system where they give candidates in their program both a block grant at the beginning of the campaign and then matching funds over the course of the election cycle. And then real briefly, I'll mention Seattle's Democracy Voucher Program. This is a very novel, kind of cutting edge public financing system, and it's created, they rolled it out in 2017. And what Seattle does is they distribute a series of $425 vouchers to, I believe it's every eligible adult voter in the city. And those city residents are allowed to distribute the vouchers to publicly financed candidates in Seattle at their discretion. And it's a really interesting concept because when we try to broaden political participation and get more people to become involved in campaigns, basically giving people $100 to give to their favorite candidates is a great way to get people focused on candidates, learning about candidates, and kind of driving up the numbers of citizens that we see actually making contributions in elections. In terms of the mechanics, for the most part, there are three kind of key parts of any public financing system. There are qualification requirements. The first thing is the candidate has to opt into the program. And then before they'll become eligible for the public money, they have to raise a threshold number of small contributions from residents of that jurisdiction. And once that happens, they are eligible for actual payments of public funds. And then as kind of the condition of receiving this public money, because it's a voluntary system, the candidates are agreeing to participate in the program. You can impose special rules on their campaign finance activities that otherwise might not be constitutional. The biggest thing that comes to mind here is expenditure limits. While we mentioned earlier that expenditure limits are generally unconstitutional, they are fine in the public financing context because they're voluntary. Another thing that's pretty common is special lower limits on contributions to publicly financed candidates, as well as only allowing publicly financed candidates to take money from individuals. They can't take corporate money or they can't take back money. And then a lot of jurisdictions also require publicly financed candidates to participate in a series of public debates And that kind of goes towards the interest in just broadening and increasing political engagement through public financing systems. And finally, I just want to talk about 3 keys to ensuring public financing success. Kind of the end all and be all is funding for the program. If the program doesn't have money, candidates aren't going to want to join it, and it's not going to be viable, and it'll probably wither and die. And in terms of how jurisdictions fund their public financing programs, the most common is your standard legislative appropriation. But there have been some interesting approaches taken. Seattle's Democracy Voucher Program, for example, is funded by a citywide property tax. And then in a couple places on the East Coast, you'll see gambling taxes and gambling revenues going into the fund that provides money for the public financing program. So there are some kind of innovative ways out there beyond just legislative appropriations. Kind of the second key to success here is updating the program. There's a lot of people don't know this, but there's a presidential public financing system that's been in place since the 1970s. And for a long time, there was pretty strong candidate participation, really all the way into the early 2000s. But Congress hasn't updated that law, I believe, since the 80s. And basically what happened was the level of funding available through that presidential system did not keep pace with the levels of spending that candidates could raise through a purely private campaign. And it just sort of withered away and became not a viable way to run for office. And I think the last presidential candidate to use that presidential system was John McCain in 2008. So that gives you a sense of how obsolete that system has become. So that really just kind of underscores the need to regular review and update these programs to make sure that they are a viable alternative to raising private money. And then the last one is just making sure that the public and voters know about these systems, and making sure the candidates know about these systems, and how they can enhance kind of democratic participation and the value of kind of everyone's voice in an election. And that's all I've got for now. Do you want to turn it over to?
Would you like to take some questions that we've received so far?
Yeah, absolutely.
Okay, great. Hold on here. Put them back up. So the first question we received was, until corporations are no longer classified as people, with limitless capacity for influential bribes, is there any hope for real reform of any level?
Yeah, certainly. I think going back to, I talked about courts have been supportive of disclosure requirements and really ensuring that there's transparency in elections. So unfortunately, Citizens United is a pretty recent decision, and given how the kind of the turn the court has taken in recent years, I don't see that being overturned. But disclosure for now is still good law, and I think it's really key to focus on, as in the reform community, making sure that campaign spending is as transparent as possible.
Okay. The second question, why do PAC contributions not give rise to corruption or the appearance of corruption, especially if we know who funds the PAC?
Yeah, so I wonder if that question is referring to contributions from PACs to candidates or contributions that PACs themselves receive. If we're talking about traditional PACs, not super PACs, PACs that make contributions directly to candidates, it is permissible to regulate contributions that those traditional PACs receive, because the interest in corruption, as courts construe it, is implicated there, because they have the ability to turn around and then give that money to candidates. So in a lot of places, traditional PACs are subject to limits, just like candidates, just like political parties.
Well, and what about the super PAC? Let's say it was the reference was to a super PAC.
Sure. So in reference to super PAC, no, and that really goes back to what Citizens United drove home. Because super PACs are only supposed to be making independent expenditures, limiting the contributions they receive doesn't implicate a corruption concern, because they're supposed to be totally independent of candidates.
Okay. Okay, and then the last question we have is, Can we force all candidates to have public financing of campaigns rather than give them the option?
That'd be nice, but no, that was one of the warning signs I touched on is courts will strike down programs. That's what happened in Arizona, where they view the programs as either penalizing non-participating candidates or outside groups, or forcing candidates to join the program just because the system becomes so enticing or just provides so many benefits that there's no viable alternative. So that's what you have to be careful when designing a program.
Great. Okay, thank you. That is all the questions we have right now.
Cool. Thank you.
Yeah, I'm Pat Ford, Senior Policy Counsel with the San Francisco Ethics Commission. Austin's a pretty tough act to follow when it comes to campaign finance matters, so I'm going to do my best here. But I think that was a really good tour through, the major tools that are available from a regulatory perspective when you're looking at campaign finance. I think you kind of should have an idea now of what is and is not available to you just from a legal perspective. I think a lot of the tools that we think maybe we would like to use, they just aren't there. So I think that's kind of one of the first steps, is knowing what is out there. And then what I hope to share with you is what it's like to be a local jurisdiction operating within this environment that Austin just laid out for you. What it's like to try to decide which of the tools are appropriate for you, how to first enact them, get them through the political process, and then to implement them. And hopefully, even though San Francisco is a different size city and maybe different, we have a different political environment just in terms of what kind of elected offices there are. Hopefully there'll be some helpful analogs to help you kind of think through the issues that you're working on in Alameda. So I will share my slides. Okay, so I'll start out just kind of introducing our commission, so you have an idea of what the Ethics Commission is, and also kind of what it isn't, kind of where our jurisdiction ends. So the Ethics Commission regulates campaign finance, which obviously is what we're looking at today, but I do want to also point out that we also regulate conflicts of interest. That's kind of what gives us our name, the Ethics Commission. That's the ethics portion of it. So that's once an official has actually been elected or appointed to office, or an employee is working for the city government, there are conflict of interest rules that apply to them to make sure that they're executing their official duties in the interest of the public and not in their own personal interest. We also have some programs that aren't as big as our campaign finance or conflict of interest programs, but are worth mentioning too. We also regulate lobbyists. So lobbyists have to register and file disclosures with our office. Likewise, different kinds of consultants like campaign consultants and permit consultants, people who help others get building permits through the city, have to file with our office. And we also protect whistleblowers. So we don't actually run the whistleblower program. We're not the people that whistleblowers come to report waste, fraud, and abuse. But if after reporting they are retaliated against, we may pursue penalties against individuals who retaliate against them. So we protect whistleblowers. And I'll point out that we don't regulate elections. So we don't handle ballot measures qualifying for the ballot or candidates trying to get on the ballot, or how or when the election's carried out. That's within our Department of Elections in San Francisco. And you'll see in some jurisdictions, these roles are combined within one office, like a Department of Elections or Department of Elections and Ethics. But for us in San Francisco, it's separate. And what our commission is actually made up of is the commission itself, which is a 5-member body. And what's kind of interesting about our commission, you don't see this with all ethics commissions, is that each of our commissioners is appointed by a different person or body. So our 5 commissioners are appointed by respectively the mayor, the board of supervisors, city attorney, district attorney, and the recorder assessor. So all different elected officials have appointing authority over our commissioners under the theory that by dispersing the appointing authority, you make the commission independent so that no single person or body can have sway over how the commission acts. And we also have executive director that the commission hires, and then 24 staff members that the executive director has authority to hire. So we're a staff of 25 people. We report directly to our commission, which is fully independent from any other organ of the city government. So we have latitude to regulate that government is the idea. And our commission originated through a voter initiative in 1993. And at that time, it had a very small staff of maybe 2 or so people. And over the last 28 years, it's grown to its current size. So it's definitely something that evolves over time, and it doesn't start out of the gate as a full-fledged city department. It kind of grew to what it is now over time. What we do as a staff, as a department, is well, we do a lot of things, but in particular, I think we can boil it down to these 4 categories. So these kind of run generally in chronological order is how I think of them. So first of all, we help people comply with the rules. So all of those different kinds of rules that Austin talked about, disclosure rules and contribution limits and public financing, those all become programs that have to be administered. So if you're someone running for office, you need to find out what all those rules are, and you need to have a place to file those disclosure reports and a place to submit requests for that public financing money. So that's a big part of what we do is we run those programs. We help people comply with the law. We also have a big public information function. So when people file, when committees file their campaign statements or those 496s that Austin mentioned, reporting independent expenditures, we're the office that they filed them with. And then a big part of what we do is making those publicly available in a way that's helpful and informative to the public. And I'll talk more about that later. And then for candidates or other kinds of committees that don't comply with our rules, we have enforcement and audits to detect and punish violations. So we audit many different kinds of committees. Austin talked about candidate committees, independent expenditure committees, ballot measure committees. We perform audits at random of different committees. We also audit all candidates that receive public funds to make sure that they use those funds in the proper way. And audits then refers complaints to the enforcement division. Enforcement also gets complaints from members of the public. Anybody, including you, can submit a complaint to our enforcement division about violations of any of the laws we administer. And the enforcement division conducts investigations and levies penalties against violators. And then the last bullet, which is the role that I play with the commission, is legislative recommendations. So this is part of our commission's mandate as set out in the city charter, is to make recommendations to the board of supervisors about what kinds of campaign finance and ethics laws should be enacted in San Francisco. So what my team does, we're a 2-person team, is we assess all the different programs and laws that our department administers, and we try to assess how well they're doing. We try to do some of the kinds of research that Alan laid out for you at the beginning. We look at the available data. We look at other jurisdictions and try to understand what they're doing. We talk to people. We engage with stakeholders, with groups like the League, Common Cause, CLC, different groups that are active in this space, and try and learn from them. And then we make recommendations to our commission, and then the commission will vote, and then we carry those recommendations forward to the board, and we advocate for those things to become law through the legislative process. And I'll mention also that our commission has a somewhat unique power, which is to place certain measures directly onto the ballot. So if they vote 4 out of 5 members to place a measure on the ballot, it goes directly onto the ballot without any need to gather signatures or to seek a vote from the board of supervisors. It just goes directly onto the ballot. And that has been used in the past. So I think that's kind of a unique power. You don't see many city commissions that have that power. So I've already touched on this a bit, but I wanted to highlight how our policy process works. I think Alan already kind of laid out a pretty good approach that he's taking to assess the issues that you see in Alameda. So ours generally looks like this. The first thing that we want to do is identify exactly what the issue is that we're looking at. What is the problem that we're perceiving, that we're hearing from people in the city? What are we trying to solve for? And then our next step is to engage with people, just like we're doing tonight. I'll later in this presentation do a shameless plug for our stakeholder meeting that's happening tomorrow, and beg some of you to come join us and share your ideas with us. But we definitely take very seriously engaging with our community and hearing from people what they think about the state of ethics or campaign finance in San Francisco. And then, like I said, we try and gather as much information as we can. We want to make really informed recommendations to our commission. So we pour through all of the disclosures that committees file and different reports that groups like Campaign Legal Center put out, and try to really understand the landscape that we're working in. And then we look closely at our programs, and we try to assess how good our outcomes are. And we take a pretty, brutal look sometimes at how things are. We don't pull punches. If we think our programs aren't working well, we'll say so, because we want to make them better. So we take a good close look at how a program like our public financing program, for example, how it's working. And then we recommend to our commission what we think the proper course of action should be. That's another opportunity for the community to get engaged when the commission has public meetings to come and share their ideas about what they think is best. And then we move forward with legislative advocacy, whether that's placing a measure on the ballot or going to the board of supervisors and trying to persuade them to pass legislation. That's what we try to end a policy project in doing, is resulting in new laws. The last time that we went through this full process was from 2018 to 2019. We did a top to bottom review of our public financing program. And I'm really glad that Austin teed that one up. That it's really crucial for public financing to review those kinds of programs frequently, because the campaign finance landscape changes so fast in such a short amount of time that if a public financing program is not kept current, it very quickly becomes obsolete and irrelevant, and people don't use it. And then it's just not useful anymore. So what we did is we looked at a program that hadn't been updated for probably 10 or 12 years in a major way. And we changed it from a 2-to-1 to a 6-to-1 match, similar to what Austin described in Berkeley. We actually looked closely at Berkeley's program when we were reviewing ours. We increased the amount of money that candidates can get. And we made a lot of changes to how the application process works. We wanted to make sure that that process was not serving as an unnecessary barrier to people using the program. So that's generally how we approach issues in our commission. So to transition to talk specifically about campaign finance rules that we have, I really appreciate the discussion about state rules, and especially the kind of umbrella contribution rule that applies now. I think that's a really good point to make, that state law establishes the framework for campaign finance rules in the state of California. And that goes back to the mid-70s with the Political Reform Act. That was a major milestone, probably the milestone for campaign finance reform in this state. And that established the framework that we still use today for campaign finance rules. So it doesn't matter if your city or your county has an ethics commission or has specific local campaign finance rules. Your local candidates are already subject to a massive body of law at the state level that applies directly to local candidates. So they're already required to file statements disclosing their finances. They're required to place certain kinds of disclaimers on their advertisements. And what you have the opportunity to do as a local jurisdiction is go beyond that. You can't really roll those back. I think the contribution limit is kind of a special case where that law contains that power for local jurisdictions to roll it back. Most rules aren't like that. You can't undo, for example, the requirement to file campaign statements. That's something that will apply regardless of what the local jurisdiction does. So I think a really important thing to keep in mind is to be very familiar with the state rules, because that's the landscape that you're already working within, is those state rules, and identifying where you think those rules are falling short. And then that's where you can target as a local jurisdiction or organization working in a local jurisdiction. That's where you can target your efforts. And as Austin mentioned, he divided up into three kinds of rules. I've here parsed it as two: disclosure and the prohibitions or limits. Then public financing is kind of a third rail of the whole thing on its own. It doesn't really fit neatly into either of these others. It's a really special category. But when it comes to your traditional campaign finance rules, you can either fit them into the disclosure bucket or the prohibition or limit bucket, or I think Alan referred to them as exclusions. There's a lot of different ways to describe them. But here are some of the major ones that we have locally. So these are examples of rules that go beyond the state framework. These are rules that have been enacted locally in San Francisco to apply additional rules that go above and beyond. So in that disclosure category, so I've mentioned that there's a requirement in state law to file a campaign statement. That's called the Form 460. You may have encountered this form before. And all political committees that are active have to file this form twice a year. It's called the semi-annual filing requirement. And then additionally, if that committee is active in an election, it has to file 2 more statements as the election approaches. Those are called pre-election statements. And they're required a certain number of days out from the election. What we did in San Francisco is we added a requirement to file a 3rd pre-election statement. And we timed ours to be the Friday before the election. So if the election is going to be on Tuesday, then that preceding Friday, we now require committees to file a statement on that day, which we thought was really important to fill a gap, because the way it used to be is if you were going to the polls, if you're somebody who still goes to the polls and doesn't vote, 3 or 4 weeks early absentee, at that time on election day, the last opportunity that you had to see up-to-date information was 11 days before the election. And that data actually was ending 2 weeks before the election. So there was 2 weeks of activity that under the state framework was not reported until after the election. And that's of course leaving out that 496 report that Alan mentioned. That kind of does fill in the gap to some extent, but not in the same way that a statement does. A statement is really a complete statement of the committee's finances. So we had this Friday report before the election. Sometimes we call it the Halloween report, because sometimes that Friday is actually Halloween. And it gives voters a last chance to see that last minute activities that we know campaigns do. Right before, there's always some big surprise. There's some big contribution or some big independent expenditure that happens. So we wanted to try and get as much information injected into the public view as we could right before the election. So that's an example of what we did. Another thing that we do similarly is we require committees that are gathering signatures for a measure to be placed on the ballot to also file statements every 2 weeks. So that provides a really constant and up-to-date stream of financial information about those committees. It only applies during that signature gathering period. But that's something that we decided in San Francisco. I say we, it wasn't me, this was before my time. I've been at the Ethics Commission for about 4 years. But was decided that it was really important for people to have insight into who was spending money to place measures onto the ballot. So that's another example of where financial disclosure goes above and beyond here in the city. A third one, this is kind of an example of maybe a not so intuitive campaign finance report, is the mass mailing report. This applies specifically to when candidates or IE committees send out those cards that you love getting in the mail around election season. This is a report that specifically applies to those. So anytime a committee sends out over a certain number of those cards, they have to file a special designated report with our office saying how many they sent and what candidates it featured, and whether it opposed or supported them, and how much they spent on it. So that was, again, to try and give people insight when they get one of those cards in the mail, that they can go somewhere and see, okay, who paid for this thing, and you know, why did they send this out, or what was it supporting, if you couldn't tell from the card. So anyway, like I said, not necessarily an intuitive one, but that's just an example of something that's been done here in San Francisco. A bundling report is another thing. This is the newest one that we have. And bundling, if you're not familiar with this term, is when somebody goes around and collects checks and hands them to the committee. So maybe this is somebody, you know, going to the office and saying, okay, I'm going to take some checks over to this candidate who wants to write a check to the candidate, and I'll you know, put them in this envelope and I'll take them all over. That's considered bundling. As it is, I think we were kind of leaving the era when campaigns are getting their contributions largely through paper checks. I think in large part we see them using online credit card processing platforms. So bundling, you know, is very physical. It's like literally gathering paper checks. So it's not something that happens as much as when I was doing campaign fundraising about 10 years ago, when checks were a lot more prevalent back then. They're not so much anymore. So anyhow, that's an example, though, of another kind of report that we have. Folks thought it was important to see who was going around and gathering up checks and delivering them to candidates. Obviously, under the theory that that was another way that folks could curry favor with a candidate, was to go gather checks. So switching over to the prohibitions and limits, you'll see already that these are all limited to candidates. The reason being, as Austin said, that it's very difficult to apply these to non-candidate committees. It's hard to apply, or unlawful to apply these kinds of rules to ballot measure committees or independent expenditure committees, for the reason that if there's no candidate that's formally affiliated with that committee, then when you give money to the committee, the Supreme Court says there's no corruption nexus. There's not an issue where you're currying favor with the candidate, because there is no candidate. It's just a committee of people who are not ever going to assume that public office. They're just supporting or opposing a particular candidate. They're not coordinating with them. So there's no potential for quid pro quo corruption. That's what the Supreme Court says is corruption, quid pro quo. So these are some of the major prohibitions and limits that we have here in San Francisco. We have a $500 contribution limit. And again, that's only for candidate committees. That's not for any other kinds of committees, just for candidate controlled committees. It's pretty low. I'm actually not aware of another jurisdiction that goes lower than that. You know, we could maybe in the Q&A get into the merits and demerits of a $500 campaign contribution limit, but that's what we have, is 500. As Alan alluded to, we have a rule that prohibits certain contractors or people who are bidding on city contractors from giving to certain candidates. The way that this works, generally speaking, is if a contractor has a city contract and that contract could only be approved by a certain elected official, then the contractor cannot give a contribution to that official. So for example, let's say you have a contract that requires approval by the Board of Supervisors. In San Francisco, if a contract is over $1 million, it requires board approval. So if you're a contractor and you have a contract over $1 million, requires board approval, you can't give a contribution to a sitting board member, nor to anyone running for board. So that's, generally speaking, how our contractor contribution rule works. We have a similar one. This is a new rule for parties to certain land use decisions. So if you're somebody who is let's say, applying for a zoning map amendment because you want to build some kind of building that's not currently permitted. You're not allowed to give political contributions to certain city officials. I think it's members of the board, city attorney, and there might be one other office. It's limited in a certain way. Another one that was already alluded to is the rule against business entities making contributions to candidates. This used to be called the corporation rule. It's now the business entity rule because we recently expanded it to also apply to LLPs and LLCs. We had already done that through regulation many years ago, but we did it through statute recently to just make it clear that it doesn't matter if you chose to be an LLC as opposed to a corporation. If you are a legally formed business entity, you're not allowed to give to a candidate. I do want to make clear, though, that a PAC that's affiliated with a business entity can still contribute. So Chevron may not be able, for example, to give a contribution to a candidate in San Francisco. But if Chevron has an affiliated PAC, the PAC can. That's referred to in the law as a separate segregated fund. So as long as that fund is operating with a certain degree of separation from the business entity itself, then that PAC can give money to the candidate. And that is permitted in San Francisco. So it's not the case that only individuals like you or me can give to candidates. PACs can also give to candidates in San Francisco. I want to highlight what I think are a couple of the main successes, and this kind of dovetails with what Austin ended his presentation with. I think these are some of the main successes that we can definitely talk about in San Francisco. One is public financing, and another is the way that we do campaign finance disclosure electronically and how we make that data available to people. So as I mentioned, we redid our campaign financing program within the last 2 or 3 years. And those changes went into effect, some for the 2019 election and the rest of them for the 2020 election. So we're still sorting through exactly how those changes played out in 2020. And I think we're probably going to want to see another election in 2022 before we make any definitive conclusions about how those changes worked out. But it definitely does look at this point like it really did provide candidates with a much stronger platform and a much more viable way forward through the program. We had higher participation rates, and candidates received money. A number of candidates who got public financing were successful and were elected to office, which isn't necessarily a causation relationship, but there's definitely at least a correlation there that we'll explore in the months and years to come. So I think that's one big opportunity for local jurisdictions to really make change in this space. I put the dollar sign there because it's expensive. We distributed $3.5 million to candidates in the 2020 election. That's not necessarily what it would cost in Alameda. That's, I think, that's 12 different candidates, 12 or 13 candidates running for Board of Supervisors here in San Francisco. Those campaigns on average cost $250,000 to $300,000. So it's a little bit different environment than what you're dealing with. But in any jurisdiction, the cost is definitely a factor. And as Austin said, if the program does not have reliable funding, it's not going to make a big change. So that's possibly going to be one of the bigger impediments to creating a public financing program, is securing funding for it. And then the other thing I want to touch on is electronic disclosure. I will admit I'm not versed in how disclosures are handled in Alameda or in Alameda County. I should be, but I don't know off the top of my head how that works. I'm sure Alan knows all about it. But I think making sure that the main disclosure forms are filed electronically as opposed to on paper is crucial. I really can't underscore how important that is. We've essentially eliminated all paper filings in San Francisco. I think we maybe have 1 or 2 stragglers out of 100 or more forms that are filed with our office that are still paper, but 99.9% of the filings with our office are done electronically. And that opens up a whole universe of possibilities in terms of what you can do with that information. You can have that feed into something like this, which is our data dashboard. These are just screenshots from some of our dashboards. And essentially what this is when the candidates or other committees file their filings, they're doing it not on a piece of paper that they fill out and mail to us, but they're doing it online through a disclosure system. And all of that information is basically sucked up into a big spreadsheet that lives online. And you can access that spreadsheet yourself. And if you're really good with computers and data, you can, interpolate and analyze that yourself, or we do that for you. And that's what the data dashboard is. So we have an engineer in our office who uses Tableau. Some of you might be familiar with the program Tableau. It's a way to create visualizations that interpret complex data and try to boil it down in a way that's really easy to see. Kind of like what Alan was doing. So you see Alan has also has pie charts and graphs that show campaign finance data. We're trying to do the same thing here in San Francisco. So the top one here shows for a specific candidate in the 2018 election for District 4 in the Board of Supervisors, which is the Sunset District. Jessica Ho, I just picked her out because I think it's really interesting what you can see here. You see her candidate committee, Jessica Ho for supervisor. It looks like she raised about $140,000, received $130,000 through the public financing program. That's what the pink bar is. And then spent $268,000. But if you look below that, this is a third-party committee, an independent expenditure committee that was supporting her, and it spent $727,000, which is what, 2.5 times what the candidate spent herself. So in total, that's right there. That's just about $1 million that was spent on that race. And you can see really easily just looking at this that the vast majority of that was spent through IE spending, not by the candidate herself. So the dashboards allow this kind of really easy high-level view. If you tried to piece that together by going through and looking at all those 460s yourself, it would take you hours. And kudos to anybody who can do that. I mean, that's a feat of accounting to be able to do that. But having computers do it for you is really the way to go. So I'm a big proponent of this. Like Austin said, disclosure is the big tool that's still available to us in this space. The Supreme Court has not thus far taken that away from us. We can pretty much require a high level of disclosure, and we can make that available to people. So if you live in San Francisco, you can go online and you can find out exactly who is paying for campaigns, and you can see where that money is coming from. And then you can make judgments for yourself about how you feel about that, knowing who is the speaker, not just what the message is, but who is speaking here is really crucial. So last slide is just some considerations that I think are important when you're thinking about campaign finance rules. Again, what's the issue that we're trying to solve? I think really having that well-defined will lead you to the right policy outcomes. And can you address it without legislating? So for example, the data dashboards, that's not something that we did through legislation. That's something that we did through some people in our office who were really good with computers. They were able to just use those electronic filings to build a really, really useful tool for people. And that's something that can be done through civil society. I mean, people like you who are engaged and are smart and have energy can do this kind of stuff. If you don't already know them, there's a wonderful organization called MapLight. And this is a big part of what they do, is they try to take publicly available information and use technology to put that information in front of people in a really user-friendly way. So I would really encourage you, if you haven't yet, to talk with them and see, are they looking at Alameda? Is this something that's on their radar? Might they be interested in collaborating with you? The person in my office that works with me on these things is Michael Canning, and he used to work at MapLight and can definitely make an introduction there if that would be of interest to you folks, because I think they may have some really good guidance for you about things you can do just from an information perspective. And then a couple other things I'll mention is who will administer the rule. There's a big difference between having good laws on the books and having good programs in practice. You can have the best laws on the books, but if there's not a local government agency that is enforcing those rules, teaching people about those rules, making regulations and making programs that work, that actually make sense and work, the rule will have much less of an impact than it would if you had all those things. So I think that's another thing, is to really understand who will administer the rules that we advocate for. That'll also guide you to rules that are going to have a better impact. So the disclosure rule, for example, has a really big administrative cost associated with it, as opposed to maybe a rule that, I don't know, maybe has something like a limit, like a contribution limit. That's probably not going to require as much administration in an ongoing way. There's definitely something to think about too. And then lastly, this is something we refer to sometimes as the whack-a-mole problem, is if you solve one issue, is it going to pop up somewhere else in a new form? The most obvious example is if you place contribution limits on candidate committees, will that create more IE activity, more independent expenditure activity? And is that a good or bad thing? It's not necessarily a bad thing, but if it is a way for people to avoid certain rules, it might not be a good thing. So anyway, I will end with my shameless plug. I really hope that some of you will consider tomorrow at 3 p.m. Joining us to talk about gift rules. We are in the midst of looking at gift rules in San Francisco. You may have heard, but 4 of our city department heads have been arrested by the federal government. So we think it's very important right now to look at ethics laws in San Francisco. And we are doing that every day. Michael and I are doing this work. And we want to engage with people, and especially with the league, to learn about what you think about ethics laws and gift laws. So definitely reach out if you're interested. We'd love to hear from you.
Okay, there. I think I am now officially unmuted. So we have a few questions. Not a great deal of time, but let's see how well we can do. So the first one, I'm going to adapt a little bit. It said, "Wow, 24 staff positions." It says, "Are commissioners on the city's payroll?" And I will add in there, compensated, or are they volunteers?
They're volunteers. All city commissioners are volunteers.
Great, thank you. Another question. Did you say that the commission can put, I've just lost, hold on a second. I think when you unshared, I lost, there we go, okay. Did you say that the commission can put measures on the ballot without approval from the elected board of supervisors? I know SF residents who complain that there are way too many local measures on the ballot.
Yes, we can. We do have the ability to do that. It's fairly rare. The last time the commission placed a measure on the ballot was 2016, I want to say, and we haven't done it since. And I agree, there are too many measures on the ballot, and that's one of the reasons why we don't do it that much. We would much prefer to work through the legislative process and not place complicated things before the voters if we don't have to.
Very good, thank you. Do you actually have a sense as to how much attention the electorate pays to the information you gather?
We do, yeah, we do monitor site traffic on our dashboard, and it's high. People use the dashboard quite a bit. I'm also the main point of media contact for the Ethics Commission. And when it's an election time, I'm on the phone all the time with reporters who are using the dashboard and asking me, oh, can it do this? Can it do that? You know, how do I pull up something for this committee? People are really excited to use it. And I've seen a huge increase in the number and the quality of newspaper articles about campaign finance in San Francisco since we started doing the dashboards.
Great. How valuable to voters are the disclosure reports just before election with so many people voting early?
Yeah, I mean, it's true, and I alluded to this, that a lot of people do vote absentee earlier in the process. There aren't a heck of a lot of people that wait until election day. But you would still be surprised, though, at how campaigns still ramp up their spending before election day. Campaigns are slow to, I think, adjust to early voting. They really do still think of election day as a big day, and there's a ton of financial activity. So we want the information to be out there, even if a lot of people have cast their votes. Yeah, I just think it's important for it to be out there.
Great. And the last question we have is, and you may or may not know this, but it might be easily referenced if to think of the San Francisco County. Does the Alameda County Registrar of Voters Office do a lot of what the San Francisco Ethics Commission does?
Yeah, I'm not sure. If you don't have an ethics commission, which you don't, then someone else in the county will be what's called the filing officer for campaign finance forms. And that varies from county to county. Different counties select different offices to do that. Some counties have their clerk do it, some have registrar, some Department of Elections. I just don't know offhand. But yeah, that will be some other pre-existing agency that has that.
But would you know whether, if they have that, are they doing the same work that your commission is doing?
Oh,
that might have been the question.
Oh, in terms of like with dashboards and campaign finance information, I don't know. I really don't know. I wish that I was more plugged into what other communities around the Bay are doing. I think, down the road is something I'd like to do more of, but yeah, I don't know. I suspect not. I had to guess, but I would really highly recommend that as, stop number one on your project is to look at that and understand exactly what they are doing. You could talk to them too. Talk to them about, have they considered, making information available in a different way, because it's important to you.
Okay, great. Well, those are all of our questions. Thank you so much, both to you and Austin. I will pass this back to our president, Susan Hauser, now.
Oh, thank you. And thank you, Austin, Patrick, and Alan, for this outstanding presentation. Thank you, those of you in the audience who have joined us tonight. Just as a reminder, you may access campaign finance documents that our league has put together with Alan's help. You can access those on our website, on our League of Women Voters of Alameda website. And in closing, I want to thank you again for attending and supporting our league. We are an all-volunteer 501c3 organization. If you would like more information on the many topics we work on or how to volunteer, visit our website at www.lwvalameda.org. And thank you and good night.